Hi, it's Nate Charles, and welcome back to the Rule of Law Brief. I want to start by giving credit where it's due. This video was prompted by a question from Christopher Colin Supko, a fellow Naval Academy graduate and former U.S. Navy SEAL. He flagged a recently leaked ICE memo and asked for a legal analysis. Colin is a serious and thoughtful public servant, and I appreciate him raising this issue. I waited a few days before doing this video, and I did it deliberately. There's been a lot of commentary online about this leaked ICE memo, but before I offered any assessment, I wanted to locate a copy of the memo and actually read it. It took me a little while to find a copy, but I've done it, and here's my assessment. To understand the controversy here, you need to start with the U.S. Supreme Court doctrine that controls it. Two cases matter more than the rest: Payton v. New York and Steagald v. United States. In Payton v. New York, the U.S. Supreme Court held that the Fourth Amendment generally prohibits law enforcement from making a warrantless and non-consensual entry into a person's home to make an arrest. But the court also held that when officers have an arrest warrant issued by a detached and neutral magistrate upon probable cause, that warrant implicitly carries limited legal authority to enter the suspect's residence, so long as there is reason to believe that the suspect is inside. The key point in Payton is not the label arrest warrant. The key point is that a judge has already stood between the government and the privacy interests of a person in their home. A detached and neutral magistrate has reviewed the evidence and authorized the intrusion. That judicial interposition is what makes the entry constitutionally reasonable. A year after Payton and Steagald v. United States, the court clarified the limits of Payton. There, officers had a valid arrest warrant for a suspect and believed he might be inside someone's home, but not the suspect's home. The court held that an arrest warrant, even a judicial one, does not authorize entry into the home of a third party to search for a suspect. That requires a separate search warrant for the third party's home, again, issued by a neutral magistrate. The court emphasized that the Fourth Amendment protects distinct interests: the arrestee's liberty interest and the homeowner's privacy interest. In the situation at bar in Steagald, the arrest warrant only addresses the former. It does not substitute for judicial authorization to invade the third party's home. The Fourth Amendment's core function is to place a detached and neutral magistrate between the government and the privacy interests of the homeowner. Taken together, Payton and Steagald establish a single structural rule: forced entry by any form of law enforcement into the home is constitutionally reasonable only when it has been authorized by a detached and neutral magistrate. So with those rules and that legal framework in mind, let's turn back to the ICE memo. Now, to be clear, the ICE memo does not contain a detailed constitutional analysis, and arguably it should have. It announces a conclusion, but it does not explain how the DHS Office of General Counsel believes that conclusion satisfies the Fourth Amendment. So what follows is necessarily inferential. Based on the result that DHS reaches, however, it's reasonable to surmise their logic. DHS appears to be reading Payton and Steagald to mean that an arrest warrant, standing alone, authorizes law enforcement to enter the suspect's home to effect an arrest. From there, DHS appears to be treating an ICE administrative warrant, specifically Form I-205, as the civil equivalent of a criminal arrest warrant, and therefore as carrying the same implied authority to enter a suspect's home, or, in an immigration context, a non-citizen's home. That is where the constitutional error lies. So let me be clear. It is not the type of warrant, arrest warrant versus search warrant, that gives law enforcement the authority to enter a home. The Fourth Amendment does not turn on those distinctions. What satisfies the Fourth Amendment is who issued the warrant and how. The authority to enter a home exists only when a warrant has been issued by a detached and neutral magistrate upon a finding of probable cause. That judicial interposition between the rights of the government to enforce the law and the privacy interests of a homeowner is the safeguard. Form I-205 has none of that. It is not issued by an Article III court. It is not issued by a detached or neutral magistrate of any kind. It reflects no independent judicial judgment. It is executive branch paperwork authorized by the exact same agency that seeks to execute it. The Constitution does not allow that. The Constitution does not care what ICE calls their documents, nor does it care how it analogizes their internal paperwork with a warrant issued by a detached and neutral magistrate. The Constitution cares whether a judge stood between the government and the homeowner's interests. Once you remove that judicial check, the analogy to Payton and Steagald collapses. You cannot bootstrap home entry authority by relabeling executive paperwork as a warrant. That's not even a close constitutional question. That is precisely the kind of abuse that the Fourth Amendment was written to prevent.